Hi, my name is Chris Nolan. I'm a barrister at Queen Victoria Chambers in Sydney. This video is called The Law of Self-Defence and it's designed to assist legal practitioners in the local court of New South Wales. Assault matters are a large part of any criminal law practice, and when people are charged with assault, they usually tell one of two stories. The first story is, it wasn't me, I wasn't there. And the alternative is that they say, yes, I hit the other guy, but he hit me first, or I thought he was going to hit me. When they tell that second story, they are raising the issue of self-defence. In New South Wales, the law of self-defence has been codified in statute. It's now found in section 418 of the Crimes Act, and the leading case is Katazinski. Section 418 requires the court to ask two questions. The first one is there a reasonable possibility that the accused believed that his conduct was necessary in order to defend himself? And when determining this, the court needs to look at the situation from the point of view of the defendant and consider both the background of the circumstances of the case, but also the background of the defendant and the alleged victim. If the defendant gives evidence that they were assaulted by the alleged victim previously or in the same circumstances, then it follows that they would feel very fearful in that situation and would feel the need to defend themselves. The court must also take into account the defendant's level of intoxication. If that first test is answered in the affirmative, the court must ask the second question, which is there also a reasonable possibility that what the accused did was a reasonable response to the circumstances as he or she perceived them? And I need to emphasize those last words, as he or she perceived them. The test is entirely subjective. The court has to ask, what would a reasonable person do if they were in the situation as it is being perceived by the defendant? And of course, that perception may be affected by drugs or alcohol. Now, these matters usually, when they run, the defendant gets up on that first test. He manages to persuade the court that he subjectively himself felt that he needed to defend himself. But they tend to go down on that second test. When the court asks itself, what would a reasonable person do in the same circumstances? They tend to make a finding of fact that a reasonable person would not have used force, or not have used as much force as did the defendant. And the key issue that usually brings the defendant unstuck is when they are asked in cross-examination whether they were able to withdraw from the circumstances. If it's the case that they were able to walk away and call the police and let them deal with it, then a magistrate will almost always make a finding that their use of force was not reasonable or that it was excessive. Now, as a final point, I'd like to say that to get up on a self-defense assertion, you need to persuade the court that you were fearful of an imminent assault from that other person. You cannot claim self-defense because somebody has insulted you. Many young men seem to think that they are justified in using physical force to defend their honor. I want to make it clear that that is not a case of self-defense, and you will be wasting your time attempting to run it. Thank you for your attention.